Tonight we look at the story that has been told about the murder of JonBenet Ramsey and why so many think her parents guilty, and what this tells us about the America she so briefly lived in.
What about accessory? They also voted to indict on accessory, meaning that you and Patsy helped someone else.
Hello and welcome to True Crime Rocket Science, the most authentic voice in true crime. This is episode 47. We're in the end game now of the series. 4 episodes to go. I think this episode and also the next one are going to be pretty interesting. This episode is not likely to be very long, but I think it's going to be packed full of some interesting content. We're going to deal with John Ramsey's response to the indictments. We're actually also going to look at Steve Thomas's response to them, and I think specifically in that area it raises some very interesting concepts when we look at what he says. I'm going to divide this episode into the response that we get via Paula Woodward's book, quoting the Ramseys. Then we're going to go into the Steve Thomas commentary on the indictments. And then in the Patreon extended version of this episode, we will look at the narrative, the longer sort of explanation that the Ramseys give in their book, Death of Innocence. Now, I've heard there were some people who were saying, if I was found not guilty of murder or not guilty of being an accessory, I wouldn't celebrate. If you'd spent probably millions on defense counsel, on PR, you dedicated, you'd had to literally uproot your life because of an event that had happened. The police were calling all your friends, all that kind of thing, and then eventually it turned out that the case was resolved in your favor, and a lot of people were saying, yes, of course, they wouldn't celebrate. Interesting. It's interesting to hear that. So we actually get the response from the Ramseys in their own words in the Death of Innocence, and I think there is some truth in this idea of it would be in very bad taste to dance a jig if they were, once they heard that they were found not guilty. I think it would be in bad taste if they shook their fists at the sky in triumph. I think you'd kind of get a sense of bad taste, I guess. I think in that respect, we must look at cases like the O.J. Simpson case where, in a trial situation, you have people looking on, and the one side cheer, and it's this huge celebration when this black guy is found not guilty, and the other side are glum, dejected, nothing happens, they don't say anything. Now, I remember also, I think it was during the Oscar Pistorius trial, I think when he was going to get bail, I remember it was a packed courtroom and photographers there, and when the judge announced that Oscar got bail, there was this shout of triumph, almost like someone had scored a goal, right? And there was that kind of sense of it. And I've got to say it's totally inappropriate in a courtroom. There was also an incident I remember when I was sitting in court, and they were showing naked pictures of the victim and in the crime scene, and there was a young, I don't know if it was an intern or something, and he was chuckling. For him it was very amusing. I don't know if it was a case that he hadn't seen a victim in this situation before, whatever, and I actually wanted to slap him in the head, but I was sort of afraid that I would be then accused of contempt of court or something and chased out of the courtroom. But just seeing that kind of levity in a courtroom made me absolutely furious. But I do think you are naive if you think someone who's accused of murder, who faces jail time and massive sanction and the ire of the public being found innocent, whether they are actually guilty or whether they are innocent. I think you're crazy if you think that they're not going to do something in celebration, whether it's smile, whether it is have a drink, whether it is hug one's people close to you, whether it is do something in a way where you sort of feel, okay, whew, missed that one, I missed a bullet kind of thing. Thank you also to the 100 or 200 people who have subscribed to this channel since the last video. If you haven't subscribed, you can click on the blue icon on the bottom right of your screen. I also want to encourage you to share the videos that you watch that you enjoy or appreciate. You can click the share button. You can share onto Twitter, Facebook. I think you can even share onto WhatsApp. You can email it. There are many different ways to share, but by doing that, you help me to grow the channel. And I would appreciate it if you can do that from time to time. It doesn't take a lot of your time, but it can make a big difference. Also, if you share on certain social media, like Twitter and Facebook, please use the hashtag TCRS. It'll just help people to find my content easier. Okay, so without any further ado, let's get started. So we're going to start with Paula Woodward and what she says about the indictments, in particular what she says about the Ramsey's response. And it's in a chapter, Ramsey Grand Jury. In fact, I think it's the bottom of page 361, right? And so this is really a comment, not so much on the it's a comment on the grand jury's decision based on what emerged in the news media in 2013, right? So it's not so much John Ramsey commenting on the grand jury decision I won't say when it came out, because it never really came out in 1999 or the next 14 years. This is really his commentary on the revelation that actually the grand jury had voted to indict the Ramseys, right? So it is really only up to the folks on Patreon who are going to get the full value of contrasting what he says here in 2013 compared to what they wrote in their book in I think it was published in 2000, so 13 years earlier. You really want to juxtapose what's said here with what was said there. That's where you really get the full value. In any event, he said, quote, "As we prepared for the grand jury results in 1998," now this is him speaking to 2013, "we had been warned by our attorneys that the system was broken, and even though it wasn't right, we should expect to be indicted for murder. And so that was what we were prepared for. We never knew other than what was publicly announced about the results of the grand jury. When we subsequently learned that the grand jury indicted us for child abuse because we were in the house and should have protected our child, it was a very deep hurt, because nothing could have been further from the truth. I would have given my life in an instant to protect John Bonet, and certainly wish I could have done so." End quote. So that is something that he's said many, many times. You hear it in countless interviews. It's almost like a stuck record where he says, I would have given my life for her, right? And there's nothing stopping him from still giving his life for her. He could, you could see him on you could start his own channel and be on YouTube or wherever, like I am, every single day, trying to solve the case, reaching out to people on a daily basis, expending all his energy on that. So it's not too late for him to give up his life in that sense. The other thing that I think is very important to stress here is that he said something about that his attorneys advised him that the Ramseys should expect to be indicted for murder, right? I think that's quite an interesting thing. I'm not sure if I agree with that. I'm not sure if I agree that that is what they should have expected. I think that is something Patsy may have worried about, and maybe she had more reason to worry, but I think he seems to be exaggerating here. The other thing that I don't really agree with is that he says we never knew other than what was publicly announced about the results of the grand jury. So the fact that he's even got to say that, the fact that he's got to say, oh, we didn't know for 14 years that we'd actually been indicted. We didn't know that. The fact that they wrote a book and published a book in 2000 suggests that they needed to reinforce this idea of their innocence, that they had to, get the public's, if the public didn't know what was going on, well, this was going to help control the narrative. The other thing that I think is a bit strange with this statement where they say, we didn't know, is if you read their book, they say something else. And also, some of the lawyers associated with Team Ramsey were making claims about a drawing sticks or a straw vote, I think, that the grand jury apparently did. And none of this is actually true. But I saw it somewhere that I think maybe the Benita papers or somewhere, I can't remember exactly, but I do notice it's something mentioned on or referenced in acandyrose.com that one of the Ramsey lawyers spoke about this rumor, and there was no way of disproving it, so a rumor like that would tend to get legs because you've got that information. There's also strong statements from the Ramsey attorney Lynn Wood, who made it also seem as though the outcome was favorable to the Ramseys. And why wouldn't it be? If you don't know what the outcome is, and then the district attorney says, we won't be proceeding with this trial because there's insufficient evidence, you've got to think, well, wasn't that what the grand jury found? He's just reinforcing what the grand jury found. Instead, it's the opposite. He's second guessing, he's undermining, he's countermanding what the grand jury decided. That's quite rare. It's quite rare for district attorneys to do that. The other thing that I think we should look at here is he says in this reference from 2013, he says, when we subsequently learned that the grand jury indicted us for child abuse, and then this is the part that's really interesting, is he says they were indicted for child abuse because they were in the house and should have protected their child. And the part that I think is very interesting is what they're implying here is that the child abuse was to do with when they were in the house or something like that, and also that they should have protected their child. Well, which child? And is it child abuse just of the one child, or is it both children, or who did John Bonet need to be protected from? And that, I think, is quite an interesting question. It's also a sensitive question, so we've got to be careful going into that area. But I think if you take those words at face value, this whole idea of the grand jury indicted us for child abuse because we were in the house and we should have protected her, I think it goes a little bit further than that, because John Bonet was struck in the face in Michigan by Burke, hitting her with a golf club. The Ramseys claim that was by accident, but that is something that didn't happen in the Ramsey home. There are other incidents as well where I think John Bonet apparently fell down the stairs or fell near a grocery store or something like that. That was quite a bad fall as well. So I think you've got to think about it beyond the way that John frames it, as though it's all to do with what happened in the house. I think it's beyond that. And I also think, if you consider what John Bonet said, it's something we dealt with in the first episode, that she was quite upset in mid-December because she saw her father so seldom. And so, when he talks about, I should have taken care of her when I was in the house. I don't think that's really as pertinent. I mean, it could be, that could be what the grand jury were thinking about, but another side of it is, well, if you're not home a lot, if you're never home, or if you too busy when you are home, or whatever the case is, you're not going to know, just in ordinary areas like bedwetting and the needs of a child, what that child needs. And it's not just the needs of the one child, it's the needs of the other child as well, right? So I find it just quite interesting the way that he frames this. And as far as I'm concerned, it's not the way that I would imagine it. It's not what I imagine the grand jury were thinking, but who knows what they were thinking. He also says nothing could have been further from the truth. And I think what he means by that is, actually, we were protecting JonBenet. We were there for her, and she was under our protection. That's what he's saying, but he doesn't seem to say it in as many words. Now, the Ramsey account is that they carried JonBenet to bed. Both parents were actually involved in putting her to bed, and you kind of get the sense that there was this careful attempt to redress JonBenet and put her safely in bed and all that kind of thing. I have my doubts whether JonBenet even went to bed that night, and I have my doubts whether on many other nights that the children were put to bed. I get the sense that the children went to bed when it suited them. I'm not saying all the time, but maybe quite a lot of the time. JonBenet had a television in her room. She had insomnia. When she wet the bed, she wouldn't go up to her mother or father. She would sort herself out. She would change her clothing and go to another bed. That was how it seems that it was dealt with. And the same with her brother. And then you also had that side of the story, the scatological behavior, and one wonders what the parents thought of that, what the parents did about that. But irrespective of that, the bedwetting seems to show that the children were struggling in some way, struggling because of too much of a certain kind of attention that wasn't good for them, or too little attention, or something that was causing them stress. And maybe part of it was the competition between the children for attention, who knows. On page 364, Paula Woodward goes on to say the indictments are numbered 4 and 7, which indicates the grand jury prosecutors presented at least 7 different alternative legal theories. And I kind of get the sense that she's mentioning this almost to say, well, if there were 7 legal theories, well, then the 2 that the grand jury voted on couldn't really be worth very much. I'm not sure I agree with that. I think the fact that you can come up with 7 different scenarios suggests that there's quite a lot going on that the prosecutors thought was going on. It's not as though they had a lack of ideas in that department. And then a little bit further down on the page 364, it's mentioned, quote, the indictments do not name the identity of the person or persons who killed JonBenet and do not list the facts that support the conclusions, end quote. And what's very interesting with that is it seems like it's a glass half empty, glass half full situation. Some people will say, well, the fact that the indictments don't name this person means that there wasn't a person, or they didn't know, or something like that. And what I think is quite interesting is the failure to name this person. I don't think that it's a case of I don't think it's necessarily a case of a failure or a lack of information. It could be the need to protect somebody. If the person was a minor or something like that, they've got a right to privacy, and so it's not because you necessarily don't know who the person is. It might be because you do know, and you've got a legal responsibility to protect that person. And I've seen a case like that here in South Africa, where everybody actually knew who this kid was, who had murdered not only his sister but his parents as well. I think he was 15 years old at the time. But because he wasn't 16, his identity had to be protected. Everybody knew who he was, but his photo couldn't be shown, his face couldn't be shown in the newspapers, his name couldn't be mentioned in the newspapers either. They refer to him as the boy often. And I mean, you could, just by using your common sense, you could tell that the boy was the only person in the family who wasn't killed. So who else could it be? And you know, the boy who was this only surviving member, you don't see him in court and he's not referred to anywhere else. So, and anyway, it did turn out to be that person, and he was eventually convicted of murdering his family. And this particular kid, his name was Don Steenkamp. He was suspected of raping his sister, and he stood to inherit a large amount of money, and he wanted to go into farming. And I think his sister I think was 14 years old, and his sister had claimed to, or perhaps threatened to tell his parents. And as a result of that, he killed her and then killed them. And then the next step was, well, he wanted to inherit the farm. He didn't want to go to school anymore. This was a 15-year-old going on to 16. And I'm just saying there's a situation where this kid's identity had to be protected. Now, we don't know whether that's the situation here, whether it's another child, whether it's somebody else. We don't know. But I suppose one's got to, but one can draw certain inferences. The bottom part of page 364 refers to the judge ordering the indictments released, and then attorney Stan Garnett writing a guest commentary. And I think I've mentioned it in the previous episode, just about the statute of limitations running out years ago. Now, I'm not quite sure I understand that. I think the statute of limitations may have run out on the child abuse charge, but I don't know if it can run out on the accessory charge. I could be wrong, because as far as I'm concerned, legally, murder is murder, and accessory to murder is also murder, but I could be wrong about that. And so I find that statement a little bit dodgy if you're going to talk about the statute of limitations running out on both those things. But as I say, I could be wrong. So we're going to go from here to Steve Thomas, and let's listen to what he said during the interview that was conducted with him by, I think, Jim Clemente and Laura Richards on CBS. Let's listen in.
In October of 1999, the district attorney, upon the grand jury concluding, had a press conference, and I, as much of an insider as anybody on this case, was led to believe that the grand jury had disbanded without any further comment or vote. Knowing that all of the persons involved were sworn to a lifetime of grand jury secrecy, he folded those true bills up, in effect, put them in his pocket, gave that carefully worded press conference that fooled me and everybody else, and for 14 years, nobody had any idea until a grand juror stepped forward and disclosed, hey, we voted. We voted.
Now, I think the part that is very easy to miss from Steve Thomas's perspective, which is the indictments basically, to some extent, favored him or his side of the story. Obviously, he was quite far over, he really focused on Patsy, and that is not what the grand jury really did. The grand jury saw it, I guess, at a different level, but nevertheless, they didn't let Patsy off the hook. And so if you think about the whole thing on Larry King and then the Ramsey suing Steve Thomas, well, you wonder, would they have been able to sue Steve Thomas if the grand jury indictments were better known? And not only that, all the lawsuits that followed. And that is something that I touched on very lightly in the previous episode. There were quite a lot of lawsuits against different media. And so what I think begs the question here is, without clarity, it would feel like so let's put it this way. let's say the grand jury voted to indict, and then the district attorney did what you would expect him to do, which is to sign them, and then there was a criminal trial. The onus and the sense of who is responsible in what happened to John Bonet would go in a certain direction. Can you see that? There would be a momentum shift in a certain direction, and instead of that happening, you had it going the other way. And isn't that exactly what the first district attorney achieved by doing what he did? And it might be crossing a line to say that that was a misrepresentation, but it certainly was misleading. It certainly did create a sense that wasn't true, and it wasn't accurate, and it led people to believe, including people very close to the case like Steve Thomas, that certain things were a certain way when they weren't, right? And then to add insult to injury, you have the same thing happening with another district attorney who takes it even further, who actually exonerates them based on DNA evidence, which is certainly not as conclusive as, again, people were led to believe. And even to this day, it seems people have been led to believe that the DNA evidence is conclusive. So you've got this double thing going on. I'm not going to take it further than that for the folks on YouTube. I will be back tomorrow, the next day, for the 48th episode, and this is dealing with Burke Ramsey appearing on Dr. Phil. That is going to be quite a interesting episode. On Patreon right now, I am addressing another creator who provides his body language analysis, and as far as I'm concerned, he gets about 80% of his analysis wrong. I just disagree with most of it. It just seems a bit off what he's saying. He doesn't really focus much on the content of the interviews, but instead focuses on mannerisms and other things. But I can't say that I really agree with his assessment. The thing that I think is interesting, I don't think it's really so much whether I'm right and he's wrong, who's right or who's wrong. I think it's an interesting debate. I think it's interesting if you have two people who disagree on something, and it's interesting then to look at it, you as a third party, you as the audience, to say, well, that makes sense, or I agree with that, or I don't agree with that. When you have these diametric views, I think it is quicker and easier to get to what you think is the truth of the matter, and I think that is quite a useful exercise to do in this case. So we'll be looking at this one and only interview given by Burke Ramsey, and that'll be in episode 48. Another thing that is quite interesting that I've also put up on Patreon is the responses both John and Burke give to Dr. Phil when they're asked about the ransom note. Have you read the ransom note? What do you think about it? And it's just quite interesting what both of them say when they are asked this question. And somebody raised a very interesting question, which I think I'll deal with in a live stream this coming Sunday, where I'll just take questions on the John Bonet Ramsey case, and you guys are welcome to join that with your thoughts, your comments, your questions. Also other things you might want me to discuss perhaps later on in the year, is why make this big deal about not handling the ransom note? Why do that? Why draw attention to the fact that they didn't really read it and so on? I think it's quite an interesting question, and I think the answer to that is also quite interesting. It's worth answering questions like that as well. In any event, thank you for listening. If you want to get the content that is on Patreon, just extended views, other commentary, other analysis, then head to patreon.com/TCRS.
Decision has his own opinion.
What we were indicted for, which was nonsense, was child abuse.